The legal validity of a marriage formed under customary law depends on whether it conforms to local custom and native legislation about marriage. Now, dissolution of a customary marriage is the bringing to an end of a marriage that was not entered into under Nigerian statute law, that is, a marriage not under the Act. Because of this, it is not a statutory marriage, and as such, it is not subject to the legal process for ending a statutory marriage. Now, the Matrimonial Causes Act contains no provisions for dissolving a customary marriage. Nigerian family law mostly stems from customary law, which is the body of unwritten standards, laws, and ordinances acknowledged by a community and accepted as obligatory and binding upon them. Now, when two people get married according to traditions and customs, it's called a customary marriage. Many cultures have binding principles that apply to the society for dissolving a customary marriage. Now, divorce is viewed as a sin in certain cultures, yet it is accepted in others that it happens when the bride's parents receive their bride price back. According to Islamic custom, a divorce can be finalized by the husband declaring it to the bride 3 times orally. Customary law marriages can be dissolved without the need for a court proceeding or a judicial declaration. This means that the parties can choose to cease the marriage without filing a formal request for a dissolution of the union. However, in order for the dissolution to take place, the partner who is fed up with the marriage must formally intend to stop it. Now, according to most conventions, the marriage is said to have been dissolved when the husband requesting the dissolution receives his money back, including the bride price and other marriage-related costs. Nonetheless, it is highly recommended that a party wishing to end a customary marriage follow the legal procedure in the closet customary court. Procedure for the dissolution of customary marriage before customary courts in Nigeria. Judicial divorce. This method of divorcing is pursued after trying and failing at reconciliation. Now, in this instance, the reconciliatory move referred to above is family reconciliation, and when it fails, the judicial customary divorce proceeding sets in. The customary court is a court with jurisdiction to hear the dissolution case. Similar to statutory marriages, customary marriages also require grounds for dissolution in order for the marriage to be dissolved by a customary court decision. However, these grounds are less stringent than those needed for statutory marriage dissolutions. A traditional marriage may be dissolved for a variety of reasons, not all of which are specific or severe, such as the marriage's failure. Depending on the customary courts, grounds like adultery, the man's incompetence, harshness, mistreatment, abandonment, and so on are needed to dissolve a customary marriage. Putting it into better context, these are the major grounds for dissolution of customary marriage: refusal to have a marriage consummated, harmful illness of a certain kind that have impacted a person's ability to conceive, a man's impotence, or a woman's sterility. Dissolution of statutory marriage. A statutory marriage, also known as marriage under Act, can only be dissolved by a state high court in Nigeria. In other words, no other court has the power to entertain a petition for the dissolution of marriage in Nigeria. The procedure for commencing the dissolution of marriage in Nigeria is by filing a petition in the High Court of State. In order for the court to consider a petition for the dissolution of a marriage, it should be convinced that the parties have tried to resolve their differences without success. To be able to dissolve the legal marriage, the court should be satisfied with the unsuccessful settlement option. Now, this is why the parties need to file a certificate of resolution alongside the petition. The party that initiates an action in court for the dissolution of marriage is referred to as the petitioner, while the other party is referred to the respondent. Grounds for divorce. There is only a single ground for the dissolution of a marriage under the Act by a court. It is that the marriage has broken down irretrievably. Section 15 of the Matrimonial Causes Act covers this. Generally, a petition for the dissolution of a marriage under the Act cannot be brought before the court until after 2 years of the celebration of the marriage. Now, this principle, however, has some exemptions by which the court may permit one of the spouses to bring a petition for the dissolution of a marriage within 2 years. Section 30 of the Matrimonial Causes Act covers this. The party that brings a petition for the dissolution of the marriage must prove to the court that the marriage has broken down irretrievably through any of these means: that the respondent has willfully and persistently refused to sexually consummate the marriage, that since the inception of the marriage, the respondent has committed adultery with a third party and the petitioner finds it intolerable to live with them, the respondent has behaved in such a way or manner that the petitioner is not reasonably expected to live with him in the marriage, that the respondent has deserted or left the petitioner for an unbroken period of 1 year preceding the period that the petitioner institutes the action of dissolution of the marriage in court, that the spouses have lived apart for an unbroken period of 2 years preceding the time the petitioner institutes the action for the dissolution of the marriage and the respondent has not raised an objection to the granting of the decree of dissolution of marriage, that the spouses have lived apart for an unbroken period of 3 years preceding the institution of an action for the dissolution of the marriage, that the respondent has, for not less than a period of 1 year, failed to comply with the decision of a court ordering him to resume conjugal rights and duties with the respondent under this act, that the respondent has been absent from the petitioner for such a time and in such a circumstance, most reasonably presume that the respondent is dead. This period is usually a period of 7 years. Within 5 years of the marriage, the respondent has suffered a conviction for a crime and has been sentenced to jail for not less than 3 years. That within 1 year of the institution of the petition, the respondent has attempted to murder or unlawfully killed a petitioner. That within 1 year preceding the institution of the petition, the petitioner has committed an offense involving intentional infliction of grievous bodily harm or intent to inflict grievous bodily harm on the petitioner. Judicial separation is different from divorce or dissolution of marriage. If the order of dissolution of marriage is made by a state high court, the lifespan of the marriage has come to an end and the parties can go their different ways and are free to marry other persons as if their former spouse is dead. In judicial separation, the spouses are merely relieved of their responsibilities to live together but do not affect other rights and responsibilities owed to each other in the marriage. Now, the parties may, however, voluntarily resume their living together and apply to court to vacate the order of judicial separation. Now, the grant of the order or decree of judicial separation is a temporary order that can be applied for at any time during the course of the marriage. Subsistence of an order of judicial separation does not prevent a party from bringing an action for an order or decree of dissolution of the marriage as shown in Section 44 of the Matrimonial Causes Act. In Nigeria, statutory marriages are typically annulled when one of the parties wants to totally cancel the union on the grounds that it is void or voidable under the terms of the legislation, specifically the Matrimonial Causes Act and the Marriage Act. When a marriage is declared void, the court ruling has no bearing on ending the union because the parties were never considered husband and wife under the law. Nonetheless, with regards to a decree of nullity marriage, a ruling that only states that there has never been a marriage may be issued in order to eliminate any possibility of confusion or obliterate any iota of doubt in the mind of the public. In Nigeria, any interested party, for example, the parent of a minor who was married without the man having obtained their consent, can file for a marriage annulment, but only one spouse may do so in cases when the marriage is voidable because the union is still legally binding until it ceases to be. Depending on the state of the specifics of the case, different laws in Nigeria, such as the Matrimonial Causes Act, the Child's Rights Act, and customary law, may apply to child custody proceedings. The child's interests are always taken into account when deciding who gets custody of the child. This is a delicate and complicated matter as stated in the Matrimonial Causes Act, Section 71, subsection 1. Now, the jurisdiction is the first consideration for anyone planning to file for child custody. Child custody disputes often fall under the jurisdiction of state or customary courts, depending on the appropriate law in specific region where the case is heard. Therefore, you must file the matter in a court within the jurisdiction of the child in question. The court typically takes the child's best interest into account when awarding custody because it is the most important factor in the case. The ability of each parent or guardian to provide a stable and supportive environment, as well as the child's emotional and physical well-being, living circumstances, education, and other variables will be taken into account by the court. Full custody refers to the situation in which a single parent is given complete custody and decision-making power over their child. Joint custody. This kind of custody involves both parents sharing parental rights and making decisions regarding the child. Visitation rights. Under some circumstances, the non-custodial parent may be allowed visitation rights, which would allow him or her to spend time with the child at home or at another location. Third-party custody. If the court determines that it is in the best interest of the child, it may assign the child's custody to the third party, someone who is not a married couple, either temporarily or permanently. The court may make this order when the court is convinced that neither of the parties is sincerely interested in the well-being of the child, none of the parties have applied for custody of the child, or the court's opinion, neither of the parties is fit and proper to raise the child. Section 70 of the Matrimonial Causes Act makes provision for granting of maintenance by the court during the hearing or after the conclusion of the hearing for an order of dissolution of marriage. Now, the order may be made by the court in favor of the party to the proceeding or a child of the marriage. The court may make an order for the maintenance of a party to the proceeding, notwithstanding that an order either of judicial separation or dissolution of marriage has been made against the party. Section 70, subsection 2 of the Matrimonial Causes Act covers this. Any child of the marriage who is above the age of 21 is disqualified from benefiting from the grant of an order of maintenance in his favor unless there exists a compelling reason for which the court should grant such maintenance as covered by Section 70, subsection 3 of the Matrimonial Causes Act. An award of maintenance can be made in favor of any party to the proceeding. It can either be to the husband or the wife, and the court has absolute discretion in granting such award and the quantum of such grant. Earning capacity means the parties of the conduct of the parties, among other factors, are what the court considers in granting an award of maintenance in a divorce proceeding. Property settlement is the process by which a marriage's property or the joint property is ultimately given to one of the parties, divided between parties, and the titles vested as a result. Section 72 of the Matrimonial Causes Act in Nigeria allows for the settlement of properties as one of the supplementary reliefs that the court may award in divorce proceedings. The court in a divorce proceeding may make settlement of property in favor of a party to the proceeding or a child of the marriage. Settlement of property by the court for the benefit of parties in the proceeding covers property included in the prenuptial or antenuptial agreement made by the parties in the proceeding. Now, just as in maintenance, a child over the age of 21 cannot benefit from the settlement of property carried out by the court in a divorce proceeding, except special circumstances exist for the grant of such settlement by the court. For any property to come within the powers of the court for the purpose of property settlement during a divorce proceeding, such property must be owned by either of the parties to the divorce proceeding. Additionally, there is no restriction to the power of the court as regards the type of property it may settle between parties. This may include real property, which includes houses and estates. It may be personal property, such as cars and other personal belongings, and it may even be money.